Okay, well, everybody, welcome. We have a really exciting interview today. We are with Nathan Peppin from the Department of Commerce. If you are already a subscriber to my page, good to see you. Welcome back. If not, make sure you subscribe, like the videos. Let me know if you have any questions. That really helps me get this information out to other homeowners and borrowers who need help. So today, with the very fancy, very cool looking logo in the corner, we've got Nathan from the Department of Commerce. The Department of Commerce governs the Foreclosure Fairness Act and the Mediation program, which is part of the Foreclosure Fairness Act. So the purpose of today's interview is just to speak with Nathan a little bit about the program. Mediation has been in play almost the entire time I've been an attorney, and it's been such an awesome tool to bring homeowners and lenders together to kind of find some solutions. So we're just going to kind of get some info from Nathan today. So let's just start with a general question, which is, what was kind of the intention behind the Foreclosure Fairness Act? Why do you think this was created, and kind of what are the goals of the Foreclosure Fairness Act in general?
Yeah, so I wasn't here when the original conversations went on, and so I will give kind of my perspective of it as I sit here today. But the reality is that there are a couple things that maybe we should talk about right off the bat that kind of lead into that conclusion, and that is that for a large part, the borrower advocates and the lender advocates and the lenders don't necessarily see eye to eye exactly on what the answer to that question is. And the kind of stated goal of the program is to prevent avoidable foreclosures. And that is a rather loose term because it doesn't communicate who defines what avoidable is. And so as you get into the program, borrowers typically have a very different, or sometimes have a different philosophy about what avoidable means. And so currently where we sit, in my view, is that the program ostensibly is an opportunity for a borrower and a beneficiary, and for everybody out there, beneficiary is essentially the person who you owe money to. It's not that simple, as you know, but for our purposes, it is. So the purpose is for them to sit down and have a conversation. If you think about when a borrower originally originates a loan, there's a lot of people involved. There is underwriting, there's the account manager, there's an appraiser, there's real estate agents on both sides, and there's actually a lot that goes into originating the original loan. And to think when a loan becomes troubled, that there's some issue with that loan, whether it be, there's a variety of, but divorce, a death, a loss of job, a loss of income. When something becomes troubled, to think that an individual, a borrower, can call a standard customer service agent and get that same level of knowledge, experience, expertise, and decision making is somewhat it's not realistic. And so this program is to put the borrower in the place where they have the opportunity to sit down with an individual, and also to have some level of representation provided by the program. They could go with an attorney like you, and oftentimes, because there are legal issues beyond the foreclosure itself, or if they have the financial wherewithal to do it, it may benefit them to have a lawyer, or there is free housing counseling available from the program if those circumstances aren't present.
Yeah.
And so the program gives both representation and the opportunity to sit down with the decision maker at the bank to have a honest conversation, and hopefully a real conversation, about what the underlying issues are and whether or not there is a workable solution for that individual to avoid foreclosure, which is not the same as saving the home. It may be a short sale, it may be keys for cash, it may be some other mechanism, it may be delaying it for 90 days. But the intent of the program is not necessarily to save the home, it is to avoid foreclosure and the financial ramifications that come along with foreclosure.
Yeah, I think that's a really great way of explaining it. I always tell my homeowners that it's a process through which we'll be able to have a meaningful conversation. And so I think a lot of people who just kind of read randomly some things online think that you file for mediation and then you get to save the home. That's not necessarily always the case, but there always tends to be, from my experience, some agreement, something reached with the bank. Even if saving the home is not on the table, there tends to be an actual conversation, a dialogue where you can go back and forth. And so from a practitioner's experience in working, I work directly with the banks and I go through mediation. That conversation, that back and forth where you can throw out kind of new, more creative ideas that maybe don't have a channel directly with the lender, kind of get help with mediation. So I think it's a great way to kind of explain what mediation is. It's a process. It's an open conversation. And I do tons of things where the homeowner doesn't even want to save the home at the beginning. They want to do a short sale or they want to get rid of it. And mediation still helps us kind of do that negotiation and have that conversation. So that's awesome.
Right. I don't think every homeowner comes with the intent of saving the home. I think there are, using just one example, a divorce where both people's income, was really necessary to be able to stay in the home. That's just not realistic anymore. I think people just want a graceful exit. And I think that's really the overall, the two options are, or the two goals of the program are to either save the home or to provide a graceful exit.
Right. To prevent the just full-blown foreclosure with all the kind of pain that comes around that. Yeah, that makes sense. So talk to me a little bit about the mediators. How do you, as a representative of commerce, view the role of the mediator, and where do these mediators come from?
Yeah, so that's interesting because we sit in a unique role, as you mentioned, because we govern kind of the overall administration of the program, and we also govern the mediation portion of the program. The mediators are, for lack of a better way to describe it, are intended to be a third party that is neutral to the situation, listening to both sides, and helping, for, again, a lack of a better word, kind of referee the situation to get to a solution. The challenge with that is that it's a little bit like the court system in a way. So my approach as the individual who oversees that is I want to get as neutral as possible. We are dealing with human beings. We are dealing with people who come to the table with, and I'm not saying this is a judgment statement, but when everybody comes to the table with some type of biases, they have some different feelings that, have come to them through their life experiences. And everybody comes to the table with those things, including mediators. But to the extent possible, my hope is that mediators sit in that role and, participate in such a way that it is neutral, that as neutral as possible, and, to a certain extent, as consistent as possible. Because I think that's where most of the problems come up when we do have situations that arise in the program that seem to have tension in them. It generally comes from expectations not being met, and that is because some level of consistency didn't happen. I just went through a different case, and this is how the mediator ruled, and now I seem, to my eyes, have the exact same set of circumstances, but I have this mediator, deciding in a different way. And so that becomes problematic. And I think that, for a large part, the judicial system is viewed that way, is that a lot of times attorneys feel and clients feel that if they're going into court, you are somewhat have an outcome that is predetermined by the particular judge that you're going to get. And I don't want the mediation program to have that same viewpoint from the advocates who are coming in on either side to, think that an outcome may be determined. So I'm not sure if I answered your question. Maybe you need to ask it again. So for me, yeah, where they come from.
Yeah.
So there are a variety of different ways that you can come into the program. There is a process for approval, but essentially it's either lawyers or individuals who are probably already mediating other mediation. So there's a group of a group of mediators called the DRCs, which are now I can't even think of the name.
Professional people who deal with dispute resolution for all different.
Yes, dispute resolution centers.
Yeah.
And mediators join those entities across the state, or there are a group of independent mediators who feel like they want to do it on their own. Some of those are pure mediators who are professional mediators, and that's what they do, and they've gone through some process to get that designation. Or lawyers. There are lawyers out there who also join the program. So if you have, if you're a member of the bar, you can join the program as a mediator as well, and still go through the approval process of the department. But it's a combination of professional mediators and lawyers who mediate. And that's, basically the way you get into the program.
Yeah, that's awesome. Kind of dovetailing off of that, can you talk a little bit about, so the Foreclosure Fairness Act that governs the mediation program has a good faith requirement. Means, basically both parties, the borrowers, the borrower advocates, the lender, their advocates, and whoever kind of shows up representing the beneficiary, all have to participate in good faith. And I'm just wondering if you can just tell us what does good faith really mean from your perspective? Why do you think that was included? Or just talk to us a little bit about the good faith requirement and kind of what that means for people kind of thinking about entering the program.
Yeah, so I think that's where, particularly right now, and maybe even before my time, that the most of the tension comes from. Is whether or not a party is operating in good faith. And again, I think that goes back to this idea that's been, promoted that, the point is to prevent avoidable foreclosures.
Right.
And so I'm actually not able to answer your question in a very good way because that answer has never really been defined. There isn't a lot of definition in the statute about what avoidable means. And in particular, who gets to pick what avoidable is. And that's where the consistency issue lies. That's where, one mediator making different decisions than another mediator may come in. For me, as the, manager of the program, my estimation is that if people come in and they have a real honest conversation about the underlying things that are going on, what the statute didn't do is it didn't go so far as to require a beneficiary to provide a workout. Yes. But there are these weird situations, right? So in most situations, it's somewhat clean cut. You do some underwriting, you look at the loan, you look at what's going on, and there are tools in the lender shop that can allow the borrower to either, save the home or not. And I think in most cases, it is fairly straightforward as to whether or not a borrower truly has the economic wherewithal to save the home. And it really is, to the most part, an economic decision. I mean, you have to be able to pay the mortgage. There are certainly market factors as far as, what value is in the house, what equity is in the house, and things like that, do tend to lead to different conclusions. If there's a lot of equity in the house and it can pay off the debt, then that is typically the route that will be done if the borrower can't, have the economic wherewithal to pay off the debt themselves. Right. If the market, like it did, during the recession, if the market's bad and there's already a significant loss in the value of the home that the bank would take back, then there's a different analysis of whether or not the borrower has an economic wherewithal to support that version of debt versus maybe the debt that was originally taken out on the home. Right. And so it's not clean cut, but ultimately my answer to the question is, do we come down, do we sit down, and do we have an honest conversation? And that's what the mediator ultimately has to decide, is whether or not there was an honest and meaningful conversation about whether or not there is a alternative to foreclosure. And sometimes that decision-making process gets very, very difficult. And by far and away, that is where, if we have tension in the program, and it's limited, because like you said, the vast majority of cases get worked out and come to some form of agreement. I think over 50% of the cases that we have come to an agreement. Yeah. And even with those that don't, they typically leave having continued conversations outside of mediation with their representative. So it's not that they didn't get to an agreement, it's just they didn't get there in mediation, but the conversation is ongoing. Right. But when it doesn't work, and there are times when it doesn't work, perfect doesn't exist in the world. It is almost always the tension exists over whether or not the parties were dealing in good faith. And that is a very difficult position for the mediators to be in, because that isn't really well defined in the statute. There are some very easy things, particularly with the borrower. Did you pay the fees that were required? Did you produce the documents in time? But it's not quite as easy on the beneficiary side or the lender side, because how and what goes on behind the scenes is going on behind the scenes. And did they truly underwrite this in a way that meets the guidelines of the, of the FHA or the VA or whoever the loan may be with? And it gets a little bit difficult at times. I think those are rare. I think they're the exception to the rule. I think in the most part, we have a fairly good program that runs fairly cleanly, but at times the avoidable that is not well defined, and that specifically relates to acting in good faith, can be a tension for the two parties.
Right. I get all that. Yeah. One thing that struck me with what you just said is the behind the scenes kind of calculations that go on. From my experience and representation of borrowers, that behind the scenes stuff can come out in mediation. And that's really one of the big benefits. When you do a direct negotiation with the bank, you can get yourself through underwriting and then they'll give you a denial reason in a letter. But if we were to get a denial reason in mediation, we usually have the opportunity to break down the numbers with the bank for them to tell us what they did and see if there's any wiggle room to change anything. And so along with that good faith requirement, there tends to be communication back and forth tends to be a big part of whether people are participating in good faith, answering questions, giving responses. That's the biggest thing that I see enforced by the mediators is like, if we have a question, the lenders are then kind of required to answer that question. Even if the answer doesn't come back in the borrower's favor, I find that borrowers feel like they have a meaningful response coming back, that they understand what's happened, that they understand where the issue is. And then a lot of times we can come to resolution because we know what is causing the denial or what is causing the problem. And so for an advocate, the biggest good faith thing that goes on back and forth is just getting transparent answers. And like you said, it tends to go fine. And the times when it doesn't go fine are rare, honestly. Lenders try to help. I have good relationships with most, if not all, opposing counsels. And we go back and forth and I say, hey, what if we try this? And they say, we can't do that because of this. And so mediation really just does kind of pull back that, whatever you want to call it, like a screen where you don't get to see what they're doing. And it kind of tells you what they are doing so you can figure out how to help.
Yeah, I think only to volley that into I think what you just said and what I just said really at the end of the day is communication. If the communication is good in the process, you're probably unlikely to get to a place where an outcome is unexpected. And where there seems to be a communication breakdown, as in with all things in life, where the communication breaks down, the process somewhat breaks down. And that's really true in this process. If for some reason one of the parties feel like the communication is breaking down, that tends to be where there's a problem.
Yeah, absolutely agree. So you touched on this a little bit, and I just wanted to circle back. You get to see all of the certificates, right? So at the end of the mediation process, the mediator fills out a certificate. They kind of say what happened. And you're saying, did you say over 50% come to an agreement? I'm wanting to put out there. How often do you see homeowners come to some sort of agreement with their bank?
So I believe I'd have to go back and look at the actual numbers. It certainly was sitting above 50% as of the last, so every year we produce a report for the legislature, which takes into account the information given to us by the housing counselors, the information from mediation itself. We don't see all of the information from the housing counseling activities because they never hit the mediation program itself. It's kind of a front door to the program that is a lower level, probably, for lack of a better word, again, a less intense version of working with your bank to try and come to a resolution. And quite frankly, the vast majority of people who come to the program itself, the overall program, don't end up in mediation. Mediation is really where that first phase doesn't work with representation, either with a lawyer or with a housing counselor. And mediation is the backstop to that front end negotiation, just saying, hey, pick up the phone, can we work something out? Because most advocates on the borrower side know who to talk to. You don't necessarily need to be referred to mediation to find out who the servicer is, who the servicer account managers are that may hold this and hold the keys to the answer to the question. Most of you aren't calling the normal customer service number when you get a client in, and you kind of know where to go and how to navigate that system. And so there's a lot of work done on the housing counseling side that never ends up in mediation. And then once we hit mediation, so the overall success of the program is actually probably much better than just the mediation itself, but mediation by itself in the difficult situations where that can't work out on the front end, we're over 50% where an agreement is reached. And again, it does not mean, like we talked earlier about, the home is actually saved. It's simply that foreclosure is avoided. in some way or another. Or even if foreclosure happens, there's an agreement around that foreclosure with how that foreclosure will take place between the borrower. And oftentimes that's okay. If I can have another 90 days before you actually do the trustee sale, that's the most typical one I see. It's time. It's
Right.
just giving the borrower time to get their things together so that they can, again, exit more gracefully than, a process by which, the negotiation doesn't happen.
Right. Yeah, absolutely. Yeah, I agree with all of that. And time is something that many of my borrowers end up needing. They say, I have a foreclosure sale day coming up. I just need, whatever it is, whether it's a school year ending, whether it's, transitioning employment, whether it's being able to save for moving expenses. Those are all things that sometimes can end in a time agreement. And you never know what the lender is going to be willing to offer in exchange for just a, collaborative process.
Right.
So those are all my questions. It was really great to have you on. Again, for borrowers out there, you become eligible for mediation when you get your notice of default. Not all lenders are eligible to go to mediation. There is a list of lenders who do not have to go to mediation posted on my website, and there's a link to it below this video. So check that out. Your notice of default will get taped to your door. It'll say notice of default right at the top, and there will be information in that notice about your options to mediation. Again, if you're unsure whether mediation is an option for you and you're in the state of Washington, you can reach out to me. I can help. You can't reach out to Nathan. He works for the program. He's just here to give some good information. But you definitely want to reach out to me or call a housing counselor. They do great work over there, depending on kind of what you're wanting and who your lender is. Just start to gather information if you've received one of those notices. Nathan, any final words before we say goodbye today?
Yeah, just jumping off of what you said, I think that the big thing is, even if a borrower isn't eligible for mediation, and even if your bank isn't a bank that is required to go to mediation, and that's, there are some exemptions in the statute for institutions that really are intended to be smaller institutions, community institutions, where the bank itself is a little bit more accessible. It's not Bank of America, where there's no way anybody even knows where your loan lives. It may live in a Texas, it may live in New York, it may live in Minnesota. With as just using one example, with a community credit union, who your people are in a community credit union, and you can call and generally get the answer to the question. But even if you aren't available for mediation, that does not mean that an attorney or a housing counselor can't help you in the program.
Right.
The program has help even outside of mediation. So it's not just mediation. That front end, again, works out most all of the issues. And having somebody in your corner that understands the process and understands how to navigate this thing is incredibly helpful to any borrower. So any borrower facing foreclosure, I would recommend, even if you have no desire to save the home or go to mediation, call the program and get help from either an attorney or a housing counselor. Housing counselor is provided for free. Attorney, you have to do on your own. But either way, the program can help you. And there are resources out there to help you navigate the situation, even if you have no desire to save the home.
Yeah. And what I hear most frequently is it's just a peace of mind. Once you have somebody else
Yeah.
who knows a little bit more, who has the time during the day to sit on the phone with the bank or do whatever it takes, you just feel a little bit less stressed out and the process becomes a little bit less scary.
Yeah. I mean, the worst situations I see are when people just take too long to reach out, and it becomes a unavoidable situation. And there's, the only advice I could give them, the best advice I could give, reach out. It can be free. And if you have the resources to hire an attorney, great. But it is invaluable to reach out in a timely manner. Just don't let it roll.
Yeah. And what I will say is this, most of the attorneys that I know that work for borrowers all do free consultations. And so sometimes all you need is a consultation, right? And the attorney will tell you, this is your time frame. I talk to people for free all the time. I know several other attorneys do as well. And so even if you don't know if you want long-term representation or if you think you can kind of get through it on your own, just have that conversation for free. Get someone to kind of validate what you were thinking you should do or give you a few more pieces of information. But I couldn't have said it better myself. Reach out for help. Don't let the time get too far. The closer you get to the foreclosure, it gets stressful, and it's too much time that you're trying to figure it out on your own when you could be getting some help. So thank you again, Nathan. It was great to have you.
Thanks.
Uh-huh.
Bye.
Bye.